Chapter 23, we deal with personal property, bailments, and insurance. So personal property as composed to real property. So real property is obviously real estate, our house, our land, anything that's attached to the real property, your driveway, your garage, if you had an in-ground pool or a shed out back, all of those would be considered part of the real property. Your personal property is anything that could be moved. So your furniture, your TV, your cars, your motorcycles, your jet skis, your boats, whatever you've got. Your intangible assets such as stocks and bonds and patents. So all those are things that you own and things that you could sell. So the types of property ownership of personal property is fee simple, which means we have the right to own it, sell it, gift it, lease it, throw it away. I mean, we can do whatever we want with it if we owe it fee simple absolute. The tenancy in common is when we own it with another person. And the key to it, so the difference between the tenancy in common and the joint tenancy, each one of those types of ownership are joint ownerships where you're owning it with another person or possibly more than one other person. And you each have a right to the asset. What happens is, the difference is what happens is after death. So if you have a tenancy in common, then if you die, it would go to your heirs. So say you own a vacation property with your brother. Maybe that's how you'd want to set it up, as a tenancy in common. So if you passed away, your children or your wife or whoever your heirs are named in your will, they would get your interest in that rental or that vacation property. The joint tenancy is probably one that you would have more with a spouse or somebody like that. So when you would pass away, your interest goes to that other person. Or maybe if it was you and a parent who owned it or something like that, then if that parent died, you would get the asset. So you'd have to have a certain type of relationship to want the other party that you're owning this asset with to get it. So that would be a joint tenancy. How we can acquire personal property, possession, and we'll talk about whether it's unclaimed, lost, or abandoned. There's different rules associated with those. We could create it, build our own piece of furniture, or build it, I want to say a shed in the backyard, but that could be part of the real estate. But create the item that we now own. It could be given to us, and we'll have requirements for a valid legal gift on the next slide. We could have a session where we add value to somebody else's abandoned property. So for instance, when I was in high school, I had this old Chevette, and I had it, for a year, and I worked at Sears, and it just died. It was one of those cars that I felt like every month there was something else wrong with it. And I worked at Sears, so I would take it to the Sears Automotive Center, and they would always work on it. Well, then one day it died, and I thought, you know what, forget it. I'm not putting any more money into it. So I told those guys, whoever wants to come to my house and take it, tow it away, it is yours. And all I asked is for them to come get it out of my driveway. And then I assumed they had the skills and the materials and stuff. They probably took it, fixed it up, made it runnable, and sold it or kept it or whatever. But that would be an example of them getting that personal property through a session and being able to sell it and make some money off of it. Confusion is a weird one. The example that I give is say you have a group of farmers who all share one of those big silos, and all those farmers are harvesting their corn and throwing that corn in the silo for the winter months. There's no way to look in that silo and say, hey, those particular ears of corn are mine. They're all going to look the exact same. You're not going to know whose corn is yours and whose is the other farmer's. So then you would each have an interest in the whole. You couldn't pull yours back out, but you would say, I've got a third interest in all of that corn or whatever. So that would be an example of confusion. So here are the requirements for a valid gift. So there needs to be donative intent. So the person has to fully intend to give the gift. They actually have to deliver it, or there has to be constructive delivery. So say it's a automobile, they give you the keys or they give you the title, something like that. And then the person who has the gift given to them has to accept it. So those three things have to happen for it legally in a court of law to be determined to be a valid gift. There's two different types. There's inter vivos and causa mortis. So the inter vivos is while the person is living. So say, you think, okay, I have a beautiful ring that I want to give to my daughter. So for her birthday, I'm going to wrap it up and give it to her, So there, that's while I'm living, I give it to her, and there it is, and she's thrilled. If it was like, okay, now I think I'm going to die, I'm going in for surgery, there's a chance that this could be it for me. And then I say to my daughter on my deathbed, hey, listen, I want you to have that ring of mine. Okay, the types of property, sorry about that, are mislaid, lost, and abandoned. So mislaid, lost, or abandoned property, the mislaid property is when you voluntarily lay something down. So for instance, you go into the bank and you take your gloves off and you lay them on the counter, and then you talk to the lady and you inadvertently forget them and you leave. Well, the person at the bank should set them aside, put them in a lost and found so that you could come back later. Now again, the company may have policies that they only keep stuff in the lost and found for 90 days or 30 days, but they're not taking over that property. They're knowing that you voluntarily left it there, and they're going to set it aside for you to come back. Lost property would be more like you go into the bathroom and a $20 bill slips out of your pocket while you're using the bathroom. You didn't do that on purpose. It was left. I mean, you don't even know it happened. Or you drop your cell phone in the store, it falls out of your purse, you don't even know it happened. I feel like the cell phone, they could probably figure out whose it is quicker than cash. So say it's that cash. When that person who finds it, they are going to have the rights to keep it unless you saw it, like you knew, hey, that's mine, I just dropped that $20 bill. But definitely the cell phone, if you can prove it's yours, you could look at the pictures, the numbers, who it's registered to. So they would definitely you would have benefit over them from that standpoint. But if you didn't know and you never found that cell phone, then they would have rights to it at that point. Abandoned property is when it's discarded by the true owner, and then in that case, they can't even get it back. So like, for instance, if I'm going to get new furniture, instead of selling my furniture like on Craigslist or something like that, because it's a pain to go through that, I normally will just take it out to the front yard, put it out by the curb, put a free sign on it, and normally within hours it'll be gone. So that's abandoned property. So that person who comes in their truck and they pick that furniture up, it is now legally theirs. I can't even get it back from them because I put it by the road with a free sign, so I kind of forfeited all my rights, and they now become the true rightful owners. Then bailments. Bailments are like borrowing. So just think of borrowing or loaning property to somebody else. So there's three different types. So there's the bailment for the sole benefit of the bailer. So say, for instance, you have a sports car that you don't have garage space for, and a friend of yours has a double car garage and they're only using one side. So you say, hey, listen, could I put my car in your garage over the winter months? And they say, okay, sure. Well, there's only a slight degree of care because they're getting nothing out of it. They're doing you a favor. So you're putting your car in there, and you're subject to what they choose to do with that garage. So if they leave the door open all the time, or they go to the store and leave it open, that's the risk that you're taking for using their property to your benefit. The bailment for the sole benefit of the bailee, so like borrowing somebody's car. So say your car is broken and in the shop and you need to get to work and you call your friend and say, hey, can I borrow your car? Well, then you have a high degree of care because it's for your benefit. It's not your vehicle, it's theirs. You better take very, very good care of it, and the courts are gonna assume that you would do that. A mutual benefit bailment is like, say, with the example of the car in the garage, say your friend says, well, sure, give me $75 a month and you can use my garage all winter. Then in that case, they have a higher degree of care because now they are benefiting from it. They're getting some money. So they do need to make sure that your car is protected and safe. Insurance is when we allocate the risk of loss to a business, another party. So we're required to have insurance on our vehicles. I mean, it's required by state law. If you have a mortgage on your house, you're required to have insurance on your house. Many people have renter's insurance. So those are, businesses have liability insurance. Those are all ways for those people to transfer the loss to somebody else. So if something bad does happen, if you do get in a car accident, if your house catches on fire or somebody, falls at your business, there's somebody else who's going to have to be responsible for that. So the term is called risk management. Many businesses will have a risk management department. The policy is your insurance contract. The premium is what you have to pay, the price for the policy. You may pay it monthly, quarterly, annually. There's normally an underwriter who represents the insurance company. And like I said, the liability insurance would cover any business activities, again, as long as it's not fraudulent or negligent. And then if you're dealing with insurance, you can be either dealing with an insurance agent or a broker. So the agent represents the company. So for instance, I use Brink Insurance and they only offer you Erie Insurance. So they are an agent of Erie Insurance. So that's what they're going to try to sell you for your car or your house or your boat. They do also offer health insurance. Now, Erie does not offer health insurance. So then they are a broker to other health insurances, and then they will quote you like 3 different health plans that they do have access to, and then you pick the one you like the best. So they're still like your insurance representative, but in this case, you wouldn't call them an agent because they're not representing the specific insurance company. They're representing you and offering you different choices. Insurable interest, in order to have insurance in personal property or in a person, you obviously have to have some sort of interest. So like your car, you own it, you have a strong interest in that car, you're going to want to cover insurance. Your house, same thing. Your spouse, possibly. So then the types of insurable interest, if it's a life insurance plan, you must have that insurable interest at the time that you get the policy. Not at the time that the person dies. So that's something to note as a side note for life insurance. Say you get divorced, if you do not update that life insurance contract and say, I don't want this person to be the beneficiary of the life insurance plan, it doesn't matter that you could die 10 years after your divorce. If you did not change that plan, then your ex-spouse is going to get the proceeds of that life insurance policy, as long as you continued to pay the premiums on it. Or maybe they're paying the premiums. As long as somebody was paying those premiums and then it was never changed who the beneficiary was, that person would get the proceeds after that person dies. So it goes back to they must have the interest at the time they get the policy. Where property's the other way, you must have the interest at the time the loss occurs. So if you're in a car accident, the day you have the car accident, is when you have to have that insurable interest. They're not going to go back to say, obviously you had the insurable interest when you got the policy, but we're concerned about when it was damaged. Within that insurance policy itself, like I said, it's the insurance contract. There'll be an effective date. Sometimes it's the application date. Sometimes it's a date in the future. There'll be duties of what the insured has to do, such as when they have to pay their premiums, how they have to notify the insurance company if there is a claim, and then cooperate if there needs to be an adjuster that comes out, or to get an estimate, or that you have to take it, like say it's your car, a lot of times you have to take it to approved body shop places. You can't just take it anywhere. Then there's duties of the insurer. So they need to investigate all losses. They need to defend against any legal suits and pay any legitimate claims. So say you are in a car accident and it is your fault, and the other party is going to sue you. They're going to go through the insurance company at least first. That's where they're going to start. And the insurance company is going to represent you in that case. Okay, so that is it.